Everyone for attending. My name is Carl Szabo. I'm Vice President and General Counsel here at NetChoice. And this is the first in what we expect to be an ongoing drumbeat every month on issues relating to antitrust and the tech industry, as well as just high-level conversations about what the antitrust standard is, how it applies to people, and what those in policy and on the Hill should know and do about it. So today we're starting off with a panel entitled Bad Side of Breaking Up Big Tech. And we've got a absolutely stellar panel. I'm not going to give you bios because, well, we have the internet, but I will give you names and quick heads up. So you got Jennifer Huddleston, who is the Director of Technology and Information Policy at American Action Forum. You've got Ashish Agarwal, who is Deputy General Counsel at Tech Freedom. You have Elise Dorsey, who is the Adjunct Professor at George Mason University's Antonin Scalia Law School, and I am Carl Szabo. So what we're gonna do is I'm gonna give kind of a couple teasers on some recent polling that we will be releasing later this week. We'll then turn it over to the panel for a panel discussion on issues like what is antitrust, what are some of the issues facing big tech, as well as what are some things going on the Hill and things to be of note. And then finally, we'll leave open a couple last minutes for questions and answers. And you should be able to submit your questions to the host via the Zoom online system. So one of the things that we wanted to really celebrate was some recent polling that we had done, because it kind of proved what we'd been thinking. And so we think that most Americans don't support the breakups of big tech, or if they say they do, they say, well, yeah, sure, break them up, without really understanding what those consequences and those implications actually mean. So we wanted to make sure that we were sane. So we hired Morning Consult, an incredibly reputable polling firm, to actually go out and do some polling to see if we were either completely wrong, or if perhaps a lot of the questions and a lot of the polling that we've seen to date doesn't actually reflect what people actually think. Now, keep in mind, this polling will not be released till Friday, so you'll have to kind of wait to get the full breakdown and details, but I'll just kind of give you a little sizzler of a couple of the things that we discovered when Morning Consult came back with their results of over 2,000 Americans. You know, we found that 43% of Americans are actually concerned about the negative consequences of breaking up big tech. 43% are worried about the negative consequences of breaking up big tech. And keep in mind, that doesn't include those who are unsure, which was a large percentage. So a majority of those with an answer are actually worried about the negative consequences. Of all Americans, 59% said they were concerned about breaking up big tech. So just without even negative consequences, they're worried about the breakups. 60% of Americans oppose governments from preventing platforms like Amazon from selling their own generic versions of products. This is what Chairman Cicilline likes to call Glass-Steagall for the internet, as he seeks to kind of criminalize these types of behaviors. In our polling, we covered questions about the potential outcomes of breakup by big tech. And by the end of our poll, 59% said they were concerned about the breakup of big tech. But one of the kind of also concerning things that we did discover is that only 7% of Americans said they were very familiar with antitrust law, and 37% said they're not familiar with antitrust law at all. So when you hear people saying, oh, a majority of Americans want to break up big tech, you really have to ask, do they know what that means? And do they know what it means when they use the term monopoly? So now we're going to turn it over to the panel for some questions from these experts and kind of get their thoughts on some of the polling that we've just kind of teased out, as well as just some of the things going on. And Jennifer, I want to start with you. You know, we saw that number, only 7% seem to actually understand antitrust law. But nonetheless, we hear terms like monopoly and antitrust being thrown around all the time. Do you think, you know, what do these words actually mean from a legal stance? And have you seen examples of them being just kind of abused or misused, not only by normal people, but also in the halls of Congress?
First, thank you, and thank you to Net Choice for having me on the panel today, and thank you all who are attending this panel or will watch it later, because it is an incredibly timely topic. And as you mentioned, we oftentimes kind of hear these words thrown around, particularly the word monopoly, without really examining what they mean and what their intended purpose was. Antitrust law serves an incredibly important purpose in American law to make sure that we have a competitive and free market that consumers can benefit from. The gold standard when it comes to analyzing most of these questions of are there anti-competitive behaviors going on? Has there been a monopoly? Is the consumer welfare standard. Really looking at, do these behaviors harm consumers in a way that they aren't benefiting from the full nature of the free market and the benefits that it might have with it. When it comes to monopolies, it's been really interesting because we often hear about the big tech monopolies. There's a little bit of funny in a word with mono being plural, but even within that, if you take something like social media or the idea of a social media monopoly, is Facebook a monopoly? Well, most of us can name another social media platform really easily in terms of Twitter or LinkedIn or Snapchat or other things like that. And the same is true for most of these large tech companies. Not only are they competing with one another on many fronts, there also are a lot of other competitors in that market. And it's a market that's incredibly dynamic, that we're seeing new entrants and even disruptive changes that can completely change the nature of what the market is. We've heard these conversations before around tech. A little over a decade ago, we would be asking if we needed to break up AOL and if Yahoo had won the search wars and whether MySpace was a natural monopoly. But it was innovation that really gave rise to this next generation of technology. And so we want to ensure that that's something that's able to happen again.
You know, Elise, one of the things that Jennifer mentioned was the consumer welfare standard. This is a term that I've heard used. Can you kind of explain what is the consumer welfare standard? What does that actually mean, and where did it come from?
Yeah, that's a great question. And, I want to echo Jennifer's thanks to you and to NetChoice for having me here today to be part of this really important discussion. As you kind of started alluding to, there's been this ongoing pushback against the big tech companies. And with that, I think right now comes a very real danger of kind of acting without fully thinking through some of the long-term consequences here, right? Some of this is riding on this kind of populist wave we've been seeing over the last few years, but some of the consequences of what's being, thrown around in Congress and other places, in terms of the effects on R&D and innovation might last long after this wave subsides. So I think it's really important to take a very critical look, and I'm, happy that you're having this conversation and happy to be a part of it. So the consumer welfare standard is the standard by which antitrust law today judges conduct, and it's the tool we use to ascertain whether certain conduct, be it a contractual term, a joint venture, a merger, is unlawful. And so it's often referred to as the lodestar of antitrust because it helps to guide our analysis and decision making here. And to try and state it succinctly, the consumer welfare standard looks solely at the economic effects of given conduct, again, be it a pricing strategy, a merger transaction, whatever the underlying conduct at issue is. And what this means for antitrust law today is that it's tethered to economics and solely focused on ascertaining the likely competitive effects of a transaction. So there's a persistent misconception out there, which is frequently floated by critics of antitrust law today, that the consumer welfare standard covers only short-term price effects. So that argument goes that, courts and enforcers only consider whether prices are likely to go up within the next couple of years when they're looking at, when they're making these decisions in the antitrust space, and really don't look at anything else. And that's simply not true, and really never has been. The consumer welfare standard is narrow in the sense that it doesn't consider social or political goals. It's only looks at, the economic effects of conduct, but it does encompass kind of the full range of potential economic effects. So for example, I took a look at all the merger complaints the DOJ filed over about a 21-month period. Not a single one of those relied solely on alleged price effects, right? Every single one of them included other alleged harms like decreases in quality or reduced innovation or R&D, lower service, those kinds of things. So it's, it's really a flexible tool when it comes to looking at what the actual economic effects are. Now that can be very difficult, but it does allow for a lot more flexibility than some of the critiques would argue. And then as to the question of where the consumer welfare standard came from, that's actually also very important and highly relevant to the discussion we're having today. So we often hear complaints today that lax antitrust enforcement is contributing to a host of socio-political problems. It's contributing to growing inequality, it's undermining our democratic values, and kind of on and on. And so critics argue that we should return to an earlier enforcement regime, which had proliferated until the mid 20th century, under which antitrust law encompassed all sorts of socio-political goals. And the problem is that this ignores the reality that that socio-political antitrust regime was plagued with problems, and that the consumer welfare standard is really a result of years of deliberate discussion and debate over how to fix that dysfunction. Right, and it was really recognized on a widely and on a nonpartisan basis. That antitrust law in the mid 20th century was just really a mess. So Justice Stewart in the 60s criticized that the sole consistency he could find within the antitrust case law was that the government always wins. And even Milton Handler, who was a respected antitrust expert and chief advisor to the original trust buster FDR, criticized that there were, quote, embarrassing holdings and dicta, which no one theory can fully explain, short of regarding the cases as fundamentally opposed to one another, end quote. So, it was a real crisis. And, that was kind of how we got to, people took a step back, kind of thought about, okay, what is it that we really think antitrust law can and should be doing? And this is how we got to the consumer welfare standard. It offered some much needed consistency, both in terms of legal liability and in outcomes. And it also helps focus antitrust analysis on maximizing outcomes for the public at large, right? So everyone is a consumer. We might play different roles in our lives at various times, right? You might flow into and out of the workforce, you might go from employee to employer, but everyone is always a consumer. And the problem, one of the big problems with the socio-political framework was, that it was, pitting different interest groups against one another. So, you would see this in the case law where, the Supreme Court would say, well, yeah, the prices are going to be higher for consumers, but, the small businesses are being harmed in this way. So, that's a trade-off we're willing to make. We're willing to hurt all of the consumers to maybe try and protect some smaller businesses. But even, when critics, again, were kind of looking back at the case law, what we were seeing was antitrust in this time really wasn't even helping small businesses. It was harming them as well, because it, was kind of across the board impeding firms' abilities to enter into joint ventures or, contracts that they needed to better position themselves, in the competitive landscape. So the consumer welfare standard not only rationalized antitrust enforcement, but it provides far and away the best standard for enforcement that's, been proffered or even tried so far.
Yeah, I mean, it sounds like back in the day, what they were doing was saying the government would basically come in and pick winners and losers between two different businesses. And the consumer welfare standard said, you know what? We're not going to decide that maybe GE should be the winner in this outcome. What we should do is make sure that the consumer is always the winner in this outcome. And that's kind of what it did. Another fun fact about the bipartisanship nature of the consumer welfare standard, every Supreme Court justice for the past 30 years has shown support for the consumer welfare standard. So one of the falsities that I constantly hear is, oh, this is just a creation by people on the right. I'm like, well, maybe, but it's been embraced by people on both sides of the aisle. Justice Ginsburg, Justice Kagan, Justice Sotomayor have all said very nice things about the consumer welfare standard. But, Ashish, I want to bring you into the conversation because we heard about putting consumers first. And only 7% of Americans are familiar with the antitrust law. Why should they care if the consumer welfare standard goes away? What does this actually mean for everyday Americans, for the constituents, for people like that?
Well, first of all, Carl, thank you for the invitation. I first became familiar with NetChoice almost 20 years ago when I was in the FTC's policy shop, and we were looking at barriers to e-commerce then, and your organization provided great information to us then, and you continue to do so today. I think that repeal of the consumer welfare standard could lead to higher prices and less innovation for consumers, both in the tech space but also across the economy. So as we've been discussing, the consumer welfare standard puts the emphasis and focus of antitrust law on consumers rather than on individual competitors. When you've been in government, it is axiomatic that antitrust law is about protecting the competitive process and consumers, not individual competitors. And that is a consensus that's developed over the last probably 60 years. It was under President Lyndon Johnson's administration that the head of the antitrust division at the time, Donald Turner, said that we need to move away from this notion that big is bad, that we need to punish companies just because they're big and successful. Certainly that continued on into the Borkian revolution in the 1980s with the antitrust paradox, and even a decade ago with the bipartisan antitrust modernization commission, chaired by Deb Garza, with many members across the ideological spectrum. Everyone agreed that the consumer welfare standard was and should remain the touchstone of antitrust law. And I think a concern that I have and that others share is that if we move away from that standard, it would allow individual companies and the government to really weaponize antitrust law. So if you look at some of the language coming out of Chairman Cicilline's report, and I give them credit for a very thorough, very lengthy, thoughtful report, but it would expand the consumer welfare standard to include protections for workers, entrepreneurs, fairness, and democratic ideals. And I think we would all agree that those are good and important values, but it's very hard to actualize that in terms of antitrust enforcement. What would that mean? Any company could complain that a competitor's actions aren't fair to that company. Because pretty much everything any company does is designed in part to expand its market share, which in most cases might end up hurting a competitor. So you really would get back to the sort of government and judges picking winners and losers, which would be bad for the economy. I think we see some elements of that in Senator Klobuchar's bill. So one of the things that it does is it defines exclusionary conduct as anything that hurts a competitor. It's a very European sort of concept. And what it would do is that if a company is accused of exclusionary conduct, basically competing, that company would have to bear the burden of proof of showing that what its actions are pro-competitive. So at the edges, that absolutely could discourage companies from cutting prices, from engaging engaging in acquisitions or joint ventures or what have you. I think that's something that really should be a concern. And as Jennifer and Elise have said, antitrust law is flexible enough to account for innovation markets. You have multiple lawsuits, major lawsuits pending right now. Let's see what the courts say before we jump in with any new legislation.
You mentioned the court cases. Elise, very public cases filed against Google and Facebook. We've heard ruminations about against other tech platforms. Can you just kind of describe what is the basis of some of these suits that we're hearing about, and then we'll just kind of discuss a little bit about them.
Yeah. So, I think at this point, as you mentioned, right, there's been a few different suits of these kind of filed against these companies. And I thought, it might be helpful also to kind of, provide a little bit of background on how we got to all of these suits coming out, because it's been a bit of a flurry in the recent months. And it's, I think, there's been this kind of ongoing frustration building with big tech, at least at the, governmental and political sphere, right? So, in the summer of 2019, for example, the DOJ announced it was launching an investigation into possible antitrust violations by leading online platforms. And that was when the House first announced it was launching its own investigation into digital markets. And, so there's really been this building pressure on the antitrust agencies here in the US to take some action, right? They're getting called into Congress and the Senate and being criticized for not intervening or not doing more. And there's also, a very interesting international angle where, kind of to Ashisha's point, the European Union tends to take a little bit of a different view on antitrust enforcement. And that has, led them to already investigate and bring cases against, big US tech companies. And that's, kind of left some of the US agencies open a bit more to some of this criticism, right? That they're not doing their job because, see, the European Union has already found them guilty, so they must be doing bad things. And yeah, I want to try and not get too much into the detail of these cases, but just kind of, talk about some high level kind of overview of what we're seeing and kind of focus on the DOJ and the FTC cases that have been brought. And so there are some similarities and some differences between the cases, right? And I think maybe the most notable similarity is that both of these are focused on monopolization and in particular monopoly maintenance under Section 2 of the Sherman Act. So both of the cases rely on allegations that the defendants have distorted the competitive process, right? That they use their monopoly power to undermine free market forces and to shift outcomes in their favor. And that they didn't do this on the merits, right? It wasn't just that they were offering better products or services. It was that they were doing something else that impeded competitors' ability to even, even if their products or services were superior, to even get to the market, to even reach consumers. And so, the violations both fall under Section 2 of the Sherman Act, but the theories of liability, once you kind of look into these two cases in particular, the DOJ's Google case and the FTC's Facebook case, are, quite different in the way the underlying legal liability is structured, or the legal theory is. So the DOJ's case against Google relies really heavily on Google's conduct, right? So specific actions it's taken and contractual terms that it's insisted upon. They allege, these three different markets. So it's general search services, search advertising, and search text advertising. And their argument is that, Google has maintained its monopoly in these spaces through anti-competitive and exclusionary distribution agreements, which help lock up the preset default positions for access points, on, however it is that you're getting to the internet, right? On your laptop, on your mobile device, whatever it is. And that, they've kind of orchestrated a whole system of, contractual terms that are making it harder for competitors to reach consumers. And it's really about, Google allegedly kind of locking up these access points. Notably, kind of, to your point in the introduction, about breaking up big tech, the DOJ hasn't, at this point at least, requested specifically to break up Google in any way, but its complaint did include kind of this catch-all, any structural relief as is needed. So I guess, that kind of leaves the door open for, some later structural relief. The FTC's case, on the other hand, is interesting because it focuses really heavily on Facebook's history of acquisitions and on two allegedly unlawful acquisitions, in particular, Instagram and WhatsApp. And so the FTC here is alleging that, again, Facebook has monopolized personal search networking, which, to Jennifer's point earlier, I think we could all, think of some substitutes. So it's interesting to kind of think about what that means. But the FTC's theory here is that, Facebook developed and executed this coordinated scheme to prevent rivals, again, from developing into real threats, but as opposed to doing this contractually, as Google allegedly did, the FTC is alleging that Facebook did this primarily through a series of acquisitions. And in this case, the FTC is specifically requesting divestiture of WhatsApp and Instagram, and potentially, even some other assets, kind of as needed to make those companies viable, outside of the Facebook platform.
So Jennifer, we just heard the description of the suits. It seems kind of circuitous to say antitrust law is insufficient, but then to see two, if not more, major antitrust lawsuits being brought. But what would the outcome of a breakup of these platforms be? I mean, we've heard from advocates that this will just unleash a sea of innovation and consumer joy and unicorns and rainbows. Are those predictions accurate, or are there other potential harms to come from breaking up these technology platforms?
Well, I think it's worth noting that the two cases we just heard described are the two probably most notable cases in that they're brought by the federal government, but we've also seen groups of state attorneys general bringing cases, and then we also have private litigation between Epic Games and Apple that also deal with concerns related to antitrust. When it comes to what could happen after these cases, particularly if we ultimately see these structural remedies and these breakups, if you see a situation where Facebook has to spin off Instagram and WhatsApp into completely separate entities, I think the question is not only would you see any increase in these things that typically benefit consumers, such as innovation, but would you actually see harm to consumers in some ways from these now smaller companies that don't have the same resources that the previous company did, as well as the fact that are you going to see a change in the ability of startups to have different exit strategies? So is this going to have a greater chilling effect on mergers and acquisitions more generally, now that we have this idea that retroactive hindsight review can be applied? It's important to note when both WhatsApp and Instagram were acquired, they received additional scrutiny. And at the time, that not only were they approved, but if you look at the press around it, these were not seen as sure bets for Facebook. In fact, they were basically made fun of in some cases when it came to Instagram, that Facebook had paid too much for this. So I think there are a couple of questions there. The first question would be, what do these separate apps have to actually look like? Does this mean that spinning off WhatsApp means that Facebook can't also have its Messenger app because then it's in the same space? These are the type of questions that are going to require a judge to really have to oversee any decisions, and it's going to really impact very minute business decisions in some ways. The other question then is also, what sort of resources do these companies have to assist in some of the other tech policy problems that sometimes get lumped in with antitrust? Things that aren't antitrust concerns, aren't competition concerns, aren't best addressed by antitrust law, but that policymakers and consumers may be concerned about. Things such as privacy or content moderation. Is a smaller WhatsApp that no longer has the resources from Facebook's ad revenue going to have to engage in some sort of advertising behavior itself? Is Instagram going to have the same resources to deploy tools for content moderation when it's dealing with a smaller staff that it can rely on? So I think those are questions we need to really carefully consider, is not just what would these breakups do in terms of the business model, but what would these breakups do to the consumer experience?
Yeah, and we talked about the consumer welfare standard, the fact that consumers are likely, or they're very high probability of harm from these breakups. Yet the consumer welfare standard is under severe attack. One of our participants asked this question. Ashish, maybe you want to start with this. Notwithstanding the nice things being said by the Supremes about consumer welfare, why is consumer welfare under such severe attack today? I mean, it's been around for quite a while. But we've got senators writing books about the need to change consumer welfare standard. The antitrust subcommittee in the House is growing to address this. Why this attack on the consumer welfare standard today?
Well, I think you've all put your fingers on it, which is that I think a lot of people would like to import other values into antitrust law besides economics. They want, there's concerns about, the platforms and speech, of course. There's concerns, particularly from, the progressive left, about just the size of these companies, and they're, so big and they're so powerful. And particularly in the last year with COVID, there's just a raw concern about the size and reach of these companies. But as we've discussed, I think the properly understood, the consumer welfare standard is able to deal with any of these really most of these values as properly understood. Senator Michael Lee put out some tweets or a statement a week or two ago talking about how consumer welfare, as properly understood, is more than just about prices. It is about quality and variety, and companies compete on a whole range of metrics, of which price is just the most obvious. So there is room in consumer welfare to address, I think, a lot of the concerns that people have. I wanted to go back to something that Jennifer was talking about, and what would happen if these companies were to be broken up. She's absolutely right to highlight kind of the financing concerns. What would it mean for innovation if smaller startups aren't able to have an exit strategy? But I want to mention two other things in that regard. One is, I think people who are advocating for the breakup of these companies, I think, should keep in mind that the economy isn't static as is. There was a point in time where people thought that Microsoft was unassailable, that IBM was unassailable, AT&T, and on and on. And the truth is, in all of these markets, but particularly in technology markets, it's a very, very dynamic economy. And if antitrust law does nothing and Congress does nothing, I think in 2 to 3 years, you'll probably see a very different competitive landscape. And that's just because of innovation and of new entrants. Seen the growth of TikTok and Zoom just within the last year or so. So it's not like you only have 1 or 2 players out there. You already have 4 or 5 of these massive players and a lot of smaller companies out there. The second point that I wanted to make is it's not like the United States is operating in a vacuum here. We're competing in a global economy. I think Senator Mark Warner and Representative Ro Khanna have pointed out that it's actually a good thing that the world's largest technology companies are American companies. It would be not good for our economy or our national security if those companies were to be supplanted by China. And I'm not suggesting at all that we should give any of our tech companies a pass from antitrust law. They should be engaged in price fixing or anything else, and they should be held accountable. But the idea that we would change antitrust law and change 40 or 50 years of bipartisan consensus solely to target these companies, when you have other global competitors out there who aren't necessarily friendly to our interests, is something that I think would be a concern to all policymakers.
Jennifer, I mean, question for you to kind of follow up on what Ashish was saying. What does that mean for a consumer like me? I mean, addressing wage inequality, greenhouse gases, these all sound like great things. Why shouldn't we just open up antitrust law to policy solutions and use that to drive forward all of the policy proposals we want?
Antitrust law is an incredibly powerful tool. It really allows the government to intervene in these markets and in these business decisions and potentially prevent certain actions. Why does that matter to consumers? Well, right now, the focus is on what are the outcomes for consumers? What is the consumer welfare? Are consumers themselves being harmed? And I think it's also important to note, we talked a little bit about how we're all consumers. Consumers can mean different things in different contexts. The people buying ads from Google can be consumers the same way that you as a user of Google can be a consumer as well. So what would it mean for consumers? Would mean that you'd have a lot more antitrust enforcement in a variety of areas. Right now, the industry that you have the most anger towards when it comes to antitrust is tech. But you could easily see that if this becomes a tool that can be used for various social or political causes, as in the past, many other industries could find themselves subject to this intense scrutiny and potential intervention in their market. The pharmaceutical industry, the healthcare industry, the energy industry, the beer industry could all find themselves under more scrutiny from government regulators if they suddenly found themselves unpopular for social or political reasons. It also impacts smaller companies who are trying to compete in the market, who are trying to maybe find the best option moving forward when they know the rules of the road. So the current consumer welfare standard provides an objective standard for everyone, including consumers, and in allowing them to know that the proper focus of the market is making sure that they do have the most welfare out there. Some of these changes have been really concerning in a way, or proposed changes have been really concerning in a way that a lot of people can directly understand. So Carl, you brought up earlier that this idea of the Glass-Steagall for tech, and that you wouldn't be able to sell your own products as well as offer a marketplace for other products. This is oftentimes talked about in terms of either Apple's own apps in the App Store or Amazon's own products, Amazon Basics or some of their other house lines when it comes to their online marketplace as well. But it would also, if you take it to its logical conclusion, when we're talking about large companies, impact the Kirkland brand at Costco, or the, Sam's Choice brand at Walmart, or, even the Trader Joe's own brand, depending on where exactly we set that size on. And many consumers enjoy the generic option. They enjoy having that option that's a little bit cheaper, and that they're getting, a different experience from, as opposed to paying the higher prices for the name brand. So I think it's really important to think about the fact that it would also really shift that vision from consumers and consumers' experience in the market to something that looks more at competitors and their experience in the market.
As a consumer, I love my generic brands. I mean, my family drinks the Kirkland brand maple syrup by the gallon, which is probably not good for a whole host of health reasons. But having that option is great. I mean, it sounds like the argument against it is that consumers should pay higher prices and we should have less choice, which seems antithetical to what we actually want. But there are some proposals on the Hill right now, and there's a mention in passing of Senator Klobuchar's bill. Elise, can you talk about Senator Klobuchar's bill and trying to suppress mergers and what that would actually mean?
Yeah. So this bill, it would do a lot of things, right? It's specifically designed to overhaul pretty significantly the antitrust laws as they stand today. And it's been couched as fostering the ability of the antitrust agencies to do their job effectively. But looking at the text of this bill, what it seems to translate to is to making it much easier for plaintiffs to win antitrust cases. So it does things like lowering the burdens of proof across the board. As Ashish mentioned earlier, it would change how we're defining exclusionary conduct to bring in a lot more things and, in a lot of ways make it a bit more confusing for reasons he discussed. On the merger side as well, it would also, change the requirement that you show that conduct is likely substantially to lessen competition to this lower standard that it would, create an appreciable risk of materially lessening competition, where materially is defined as just more than a de minimis amount. It also shifts the burden of proof in some significant cases or instances. So it would shift the burden of proof for certain merger challenges and require the parties to certain acquisitions to prove out of a presumption that they should not be allowed to proceed, which is, a pretty drastic change to, the way the law is today. And on the conduct side, similarly, it would, amend the law to create a rebuttable presumption of harm for, so-called dominant defendants. And I think there are a lot of very real concerns with the proposed legislation, including that, flipping the burden of proof against the defendants in this way seems to be, really a drastic step that shouldn't be undertaken lightly, especially, in the US, we take the rule of law very seriously, and that's really a pretty monumental change. To take a step back for a second, a key premise of this legislation also seems to be that it's simply too difficult for the antitrust agencies to stop anti-competitive conduct today. Now, that's really a testable proposition. We can look at the cases the agencies are filing and see how they're doing in court. And Jan Rybnicek, who, I've had the opportunity to work with quite a bit, and who is an excellent antitrust attorney, kind of looked at the data and found that over the last 20 years, the DOJ and the FTC have prevailed in nearly 85% of merger challenges they filed in court. That's really an astounding win rate, especially given, again, the text of this bill that would across the board lower the standard and in some cases go so far as to flip the burdens of proof in these cases. And there are, a lot of reasons to kind of think that that's an astounding win rate, there's frequently this rebuttal by critics that the agencies are just really good at picking cases to bring, right? It's, these selection effects. And I've worked with both agencies and absolutely agree that agencies, do a really good job of thoroughly working through the issues and, thinking hard about which cases they want to bring and where they really see harm. But it still takes two to tango, so to speak. So if these cases are going to trial, it means not only that the agency selected them, it also means that the parties were willing to litigate, which presumably means they thought there was a decent chance they could win. So, there are selection effects on both sides of the equations, and it's not just the agencies dictating which cases are litigated. So that 85% win rate isn't fully explained by agency choice alone. And remember, that rate doesn't even include a lot of deals, right? It doesn't include those deals that were abandoned once the agencies filed a complaint or otherwise indicated to the parties that they were going to challenge the merger. It doesn't include those where settlements were achieved, which, again, I mentioned some data I pulled earlier of, regarding DOJ filings over a 21-month period. There I found, over that whole entire period, only 4 of the complaints that were filed did not include simultaneous settlement agreements. So that's, the filing of a complaint and a simultaneous settlement happens quite frequently. And again, kind of shows that the agencies often don't even need to get to court to, get remedies and to solve these problems. And of course, the data also doesn't include, because, it can't, those deals that the parties, that never materialize, right? The parties consider and reject before they even get to the HSR filing, which, having worked in private practice for several years, I can also assure you does happen even in the big tech space. So, it's pretty clear the agencies can and routinely do already win at trial. So, it's kind of unclear the problem this legislation is actually solving. And, I think it, also, to your point, threatens to do potentially quite a bit of harm, right? It raises the cost of, conduct kind of across the board, right? It puts you at a lot of risk as a company. It makes it much harder, in particular, for small companies, right, who kind of rely on this pipeline of, being able to, build a company, potentially sell it off, it's impairing there. And it's also, when you're creating a, more aggressive, more, intervening regulatory regime, that tends to disproportionately harm smaller businesses who don't have the resources, to, spend so much additional costs on, legal and all of those things. So I think that's a very real threat. And there's a lot of, potential for harm here.
Go ahead, Jen.
Sorry, so if I can just jump in really quick on and further some of the things Elise said. I think one of the things that's really notable with how much of a rewriting of antitrust law this bill would potentially be is how many different industries it would impact. That this really is something that would impact the American economy across the board. Almost every industry would be impacted in some ways, from agriculture to finance to big tech. And that we really need to question the impact. Not only would it have on the giants in those fields, but on the smaller businesses and on the consumers, on the fact that you would have a lot of change just to how the basics of these laws operate.
Yeah, I mean, if you look at our criminal law, at least, you said that it would basically upend it. Basically, you're guilty until proven innocent. And then we're getting upset that law enforcement agencies are picking cases where they think there is actual bad actors rather than just going after everything. I think those are two things that, seem kind of nuts from our law enforcement perspective. So, we've talked about some of the policy proposals coming from the Hill so far. We have Glass-Steagall for the internet, which basically says that I can't get my Kirkland brand maple syrup at Costco anymore. We've got the Klobuchar approach, which would kind of upend justice systems. I'm being a little hyperbolic on that one, but Ashish, do you have any policy recommendations that maybe people could consider? I know that you've thought long and hard about this.
I do, Carl. Thanks. First of all, I want to say that this is all very personal to me too, because I am also a consumer, and over the last year or so, as it's happened, more or less every other day, a package appears at my doorstep from Amazon. And I have said to my lovely wife many times, honey, we have many other purchasing options. There's a Target, a Costco, Walmart, down the street, or maybe we just don't buy anything, at all today. That latter message hasn't resonated quite so much, but I'm working on it. But the point is that even in the online space, there are many other retailers with names that you've heard of, where people have options. To your question, there's so much pressure. We all know how Washington works. There's so much pressure these days to do something about antitrust in response to very populist concerns from all across the spectrum. So we have been giving a lot of thought. What are some things that people who believe in traditional antitrust concepts could get behind? Because it's much easier to be for something as an alternative to what I would say are some bad ideas. But I think some of the things that I think people can and should be for are outlined in Representative Buck's third way report. So I think more funding for the antitrust agencies is something that could make sense. Representative Buck and even Chairman Cicilline persuasively make the case that antitrust funding for the agencies has not kept up with the growth in the economy. That's something that certainly could make sense. I also think that Representative Buck's call for more data portability and interoperability among the platforms is something that makes sense. He agrees, as I agree, that it's too early and maybe ultimately will be completely unnecessary for there to be a federal standard, but that is something that could, data portability and interoperability are things that could help improve competition and help consumers in online marketplaces. And beyond that, there are things that kind of people who believe in traditional antitrust concepts have been calling for a long time, and I think would still make sense, like with the repeal of some antitrust exemptions, so that antitrust law can extend to more of the economy, particularly to nonprofits. Nonprofit hospitals are a big source of consternation in terms of healthcare costs. Acting Chairwoman Slaughter of the FTC has called for antitrust law to pay more attention to racial issues and issues of labor mobility. Antitrust law protects all consumers regardless of race or anything else. But there are ways that antitrust law can constructively address those issues, such as with things like occupational licensing and overly aggressive non-compete agreements. So I do think that there are a number of things that antitrust traditionalists can and should be for as part of this debate.
Yeah, I really appreciate that. We're going to open up to Q&A. So people joining us want to ask questions. If you could just drop them, there's a question and answer option on the Zoom, so you can just drop them right in there, would be great. While we wait for a couple of questions to come in, I mean, one of the things that I think, Ashish, you mentioned, Jennifer, you mentioned, is that a lot of these policy proposals we're hearing are essentially about much, much more than just technology platforms, that there are aspirations to use any changes in antitrust law to impact other businesses. It's something that I've often called tech as a Trojan horse. So it's just one of the things that concerns me when we get so laser focused on tech and antitrust, that we need to be aware that that threat is coming. So we do have a question coming, just came in. So say Facebook is forced to sell Instagram, how would that harm consumers? Jennifer, you alluded to that a little bit earlier. Thoughts about how that would actually be a harm to consumers?
I think what we would see are a couple of harms. The first would be the fact that consumers may be less likely to benefit from future mergers because there may be an increased hesitancy given the idea of retrospective review being involved in mergers in general. In terms of what a actual separate Instagram and Facebook would look like, I think it would be very different in terms of what sort of resources that each platform had, and as a result, what that meant for consumers. I also think it would be a question of what and when each platform was able to innovate or was willing to innovate to keep up in the social media marketplace if they're constantly having to go to a judge to get permission of, is this within our framework of what we're allowed to do? And then finally, I think there's another element that we haven't really talked about, which when we talk about that kind of innovation and what comes next, is what does this mean for the teams at some of these companies? Will Reinhardt, who was previously at AAF and is now at the Center for Growth and Opportunity, has written a piece about how breaking up big tech also means breaking up some of these teams that have been the drivers of innovation, breaking up some of these creative talent minds and creating barriers where they won't be as easily able to work together. So that will also harm consumers in terms of what would Instagram look like in 5 years may be very different than what it would have been if we had allowed something that wasn't creating this harm.
Yeah, she shows a whole thing about Tom Brady, that maybe he wouldn't have been the superstar everyone thought he would have been without Bill Belichick. But another question came in on, there has been a lot of discussion of using antitrust to deal with issues of content moderation. I know that this is certainly called. Would antitrust be effective in dealing with content moderation?
Go ahead, Jennifer.
I was to say, I don't want to monopolize the conversation here, but I think certainly this is one of those cases where we have seen calls to use antitrust for policy tools that it wasn't designed for. And there is, at a minimum, no guarantee that separate platforms would have any different terms of service than the current big platforms have. And I'll turn it over to Ashish to.
No, I agree completely, Jennifer. I mean, I think these are just two different issues. This is another example of a different value, kind of free speech concerns that are, the people are trying to graft onto antitrust law. And Jennifer's absolutely right that if you were to break up, some of the platform companies, it doesn't mean that at all that you'd have some of the policy results that people seem to want. And in fact, it seems to me to be a little bit more about wanting to maybe punish some of these companies for decisions that people don't like, rather than a constructive approach, thinking that, hey gosh, if we do X, Y, and Z, if we repeal or modify Section 230, that it's going to lead to this policy outcome that we want. Because then ultimately, and I'll just commenting a little bit further there, it's ultimately not even about Section 230, it's about the First Amendment. And you have these companies with their own First Amendment rights. So it's just they're just very, very different animals.
Fair enough. And Elise, second to last question for you. And this comes in from anonymous attendee. There's been a lot of discussion surrounding barriers to entry in digital markets. I think we hear this argument a lot of times. In fact, there are hearings upcoming on the issue. Are barriers to entry in digital markets relatively high or low? So are there higher barriers to entry or lower barriers to entry in the digital markets?
Yeah, so I think, this is, hitting on something, again, we've kind of been, dancing around throughout this discussion, right? Which is, the conversation often lately, right, has turned to, big tech and digital markets and kind of treating them often fairly monolithically, right, as if they were all kind of the same thing. And the reality is, right, these digital markets today, especially, right, they refer to all sorts of different kinds of products and services and all sorts of different kinds of business models. So I think the answer is, in some instances, probably the costs of entry are higher and entry is probably more difficult, but in other circumstances, it's certainly much easier. And so I think that's, part of, what's going on in the current conversation is, if we're treating everything the same, even within big tech, that's probably going to be a problem. And, introducing these, across the board, broad scale solutions when, we have, evidence of maybe potential problems in certain areas, treating everything in big tech the same isn't necessarily the right option. And, to Jennifer's point as well, certainly treating everything outside of big tech exactly the same probably isn't the right way to proceed either.
Yeah, I mean, the services like Shopify, most people hadn't heard of them 6 months ago, and they've been the thing that's kept small businesses alive. Okay, last question for Jennifer, and then I'd like you guys to think about closing thoughts. And by closing thoughts, one takeaway that you want listeners to remember. So Jennifer, for you, the last question. thoughts or observations on New York's proposed antitrust reform bill, basically converting antitrust law to a, quote, abuse of dominance standard, basically what they do in Europe?
I think the European model in general is the wrong one to take. I do think this does draw attention to the need to pay attention to what's going on in the States. I referred to earlier that we've seen cases brought by various groups of state attorneys general, at sometimes bipartisan, sometimes we'll have a group of Republican attorneys general and a group of Democrat attorneys general bringing two different cases. But I think that when we look at the European model and what we see going on over there with the Digital Markets Act, as well as some of the cases, that moving away from a consumer welfare standard to a big is bad and this abuse of dominance return would have consequences in terms of going back to that earlier era of antitrust, where there was that degree of uncertainty in what these laws mean. And as a result, consumers lose out on potentially some of the innovations and some of the beneficial transactions that would have improved their lives in a way that we can't necessarily always predict.
Okay. Elise, closing thought, singular.
Yeah, so one of the things I just think is really important in this debate is, again, to kind of grapple with the history of antitrust. So again, we had a socio-political regime. We experimented with it for decades. It didn't work, and that's how we got the consumer welfare standard. So if we're if we're seriously considering going back to that socio-political regime, I think there are a lot of questions around how do we avoid, the exact same pitfalls and ending up, kind of in the same mess again.
Sheesh.
America has the most dynamic and innovative economy in the world, and I think at least some of that is due to the legal and political landscape that we've created that rewards successful companies and doesn't punish them. I think before people consider really moving away from that bipartisan consensus of the last 4 decades, let's see how these court cases play out. Let's see if antitrust law is sufficient to
And Jennifer.
Antitrust law has been an incredibly powerful tool, and it's an incredibly important tool to have to preserve the free market and a prosperous economy. But because of that, we want to make sure it's being used for principled reasons. And so when we're examining these calls to change antitrust laws, we need to ask, why are these calls occurring? Is there behavior that is not adequately being captured, or is this coming out of that kind of sense of animosity against a particular industry?
Okay, great. Well, thank you guys so much. You can follow Jennifer at JR Huddles and at AAF. You can follow Ashish at Ashish Agarwal on Twitter as well. Elise, you can find her over at GMU Law School doing amazing things, and you can follow NetChoice at NetChoice on Twitter as well. Thank you guys so much. I love all the work that you do, and this has been incredibly helpful, and I really appreciate it.
Thank you, Carl.
Yeah, thanks.
Thank you. Have a good day.